All right. Hi, this is Curt Verone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for October 13th of 2025. Brad, go ahead.
Let's start in my new home state. Let's start in Florida. So we have, and I am all in favor of this, but we have a Florida EMS agency in Escambia County is trying to recoup about $18 million in unpaid EMS bills. Most of these are probably going to be, well, I shouldn't say most. Let's say a lot of these are probably from co-payments, deductible portions. But they talk about a lot of these are from frequent flyers that haven't paid, so maybe they don't have insurance and they're getting private pays. But I just want to, mention. So normally, fire departments and ambulance companies don't always go after the patient. A small town sometimes, not for profits obviously are more forgiving than for profits. But normally, because in the collection world, you got to sue it. And if the co-payment's $50, $100, you spend more time and money on attorney's fees. We used to do these. I did these for about 2 months when I realized this is a horrible thing. Like in New York State, where we were trying to collect ambulance fees, and we'd have millions of dollars we're trying to collect. But when you go to like small claims court, right? Because it's too expensive to sue in regular court. So you go to small claims court, but you can only bring 5 cases a month, right? And
Oh,
so
really?
yeah, in New York,
Oh, that's
otherwise and it really hampers these collection activities, but they would otherwise take up the whole docket
see now
saying,
we have another way of doing it in Rhode Island, and I think it's probably the same in New York. Is something that we're going to talk about in a little bit. The right to a jury trial is the small claims court is before a district court judge, and there's no juries at district court.
right.
So then the person, even if it's a $10, $20 thing, now they have a right to a de novo jury trial at Superior Court. And
Yep.
so now what might be a 25, now you know what a Superior Court jury trial is going to cost you, and it just doesn't make sense. So small claims is one thing between two parties, but and there are firms, there's some firms, and I've used them, I've worked with them before, done different things, but they're like litigation mills where they'll file, at least in Rhode
Right.
Island, they'll file hundreds of collection cases, and they have a first or second year lawyer out there schlepping and handling the grunt work of it. But
Yeah,
yeah.
and so it's just not profitable necessarily, but to collect it. But it's interesting. So the county releases a statement saying, "Listen, we're not trying to serve as a disincentive. These are my words to calling the ambulance." But the reason I use the word disincentive is that's a Medicare term. So Medicare, there's a reason there are copays. In fact, in many instances, the failure to collect a copay, to attempt to collect a copay, and let me be more specific, the offering of a contract to a municipality where you say, if you give us a contract, we will not collect the copays. That's a federal felony, 42 USC 1322 AB2.
Mhm.
I know that because that was my law school mock trial. But nonetheless, it's when you're offering a bribe, saying, "Don't give up. If you give us this contract, we won't do what Medicare requires us to do: collect copayments." So why are copayments mandated by Medicare and insurance companies, et cetera? They are an intentional disincentive for the use of unnecessary services. So they're set maybe 25, 50, $75. They're set in an amount which is high enough to be a disincentive to not necessary use, but not high enough to discourage somebody from saying, "Oh, I'm having a heart attack. Yeah, but I can't afford it."
Well, I,
Um,
I thought Medicare and the insurance companies, if it was not medically necessary, would not pay for it.
Well, if it's not medically necessary, they're not paying at all, right?
Well,
But
well,
if it's medically necessary, but right, there's still a co-payment, which is
well,
normally 50 or
yeah.
$75.
Let's talk about, because this when I read this headline, which is why I include it, it's not all that great, newsworthy stuff, but it raises a dilemma in my mind, something that I think is one of the reasons why I kind of I focus more on firefighting than EMS because there's an inherent problem that I think lawyers, judges, insurance company administrators, and even some fire chiefs who've been removed from frontline stuff are overlooking in this area. Okay. And it's a paradox. And the chief kind of touched on a little bit. The chief was saying, don't call EMS, don't call 911 for the flu or for this or for that.
Right.
It's not an emergency. You don't want to tie up an ambulance for that. Okay. But call for an emergency. Okay. So he's putting it on, they want to put it on the person not to call 911 unnecessarily. Okay. In addition, the insurance companies won't pay if it's not an emergency. Okay, so you have that kind of a dilemma. And then we have firefighters respond, and there's consequences if they don't transport somebody. Somebody says, I'm sick, I want to go.
Right.
But here we have professionals who are trained to evaluate patients saying, this is a bogus call, but
Right.
we've got to transport. Why do we have to transport? Liability. We're worried about liability because out of 100 cases, you're right 99% of the time. That one time that somebody's got an abdominal pain that you think is just they've got whatever,
Right.
indigestion.
Or an aortic aneurysm or something.
You know what I'm saying? So out of concerns of liability, we've got to transport anybody. So in other words, here's what we're doing. We're telling people don't call 911 unless it's a real emergency because we're not capable of determining whether it is an emergency or not. And I said, there's some irony there
Yeah.
that, because if you call, we're going to transport you. And here's the other side. We don't think it's an emergency, but we're going to transport you. But as far as Medicare and Medicaid and insurance goes, oh, it was an emergency.
Right.
Because we need it to be an emergency for us to recover the fees.
Right.
So it's like, I don't know, there's an inconsistency there. And I feel for the medics out there who are confronted with this every day. It's a bogus call, but we got to transport because we're worried about liability. And once we transport, we got to make it seem like it's an emergency so we can get paid. You know,
Yeah.
and ERs. I'll be honest. My son Andrew, he was a career firefighter, got into medical school, wanted to be an ER doc. And, he had worked on an ambulance and all that before. And he gets in medical school and he goes, "No, I don't want to be an ER doc anymore because what we do as firefighters, we drop that person off at the ER. Now the ER doc's got to deal with it. And he's confronted with the same challenges."
Right.
And so he became a trauma surgeon because he says, people don't come to a trauma surgeon with fake injuries.
Right. Right.
So he says, when I deal with something, it's real. It's a serious life-threatening condition. He says, I'll deal with them all day long, but I don't want to have to deal with. So anyway,
And
I
I'll give
think
you the
there's a
advice.
paradox. Go ahead.
Right. I'll give you the answer. So the answer because we teach billing compliance all the time, my firm, and which is supposed to prevent fraud, et cetera. So what's supposed to happen is the EMT paramedic, right? Likely EMT if it's not really necessary, right? Is supposed to tell the patient, we will transport you. There's actually even a form they're supposed to use, don't have to use, for saying this may not be medically necessary. And the EMT is not supposed to doctor the form in any way to make it, oh, they had slight difficulty breathing, they have an unexplained this. They're just supposed to write down the facts, and then the billing company or the EMS agency's in-house billing, either one, has a non-delegable duty, so it's ultimately the responsibility of the EMS agency to determine whether the call was medically necessary. And based on the true and accurate pre-hospital care report, ambulance report, the billing company is supposed to determine, was it medically necessary? Now, Medicare has rules for that. What was the dispatch? All right, what did the dispatch come over? So if the dispatch was one thing, but the actual call was another, there are different rules. But that shouldn't be on the provider to determine medical necessity, except that there's a form which you're supposed to, but don't have to use to say this may not be medically necessary, but we'll take you anyway.
I was in a meeting of another agency sitting in. I just happened to be there, and they were going through this, and a person from the billing company was telling the medics what to put on that form so that they could get paid.
Total billing fraud, and I've seen that a million times. You're right.
Okay, and so but again, we're caught in this like paradox where It's not an emergency. It is an emergency. It's an emergency for this. When we're going to try to talk you out of going, it's not an emergency. But then when we try to justify why we transported you, it's an emergency,
Yep.
and you're stuck in that paradox, 15, 20 runs a day. If you're working a 24-hour shift,
Right.
you're stuck in the middle of that mess.
And Escambia County had one person you report, right, that took multiple trips in a day
Yeah.
and in a
I've
month and
we've
just
dealt with
racks up
people, they call
$40,000 of bills.
4 or 5 times a day, and it's just they're frequent flyers. And to me, they need either a psychologist, a psychiatrist,
Right.
or at least a social worker.
Yep.
They're begging for that. This is not, tying up EMS
It's
for something like
abusive.
that.
We
Yeah,
we
it
used to
is.
have it. I apologize for this term. It's just what we use. But in New Orleans, we used to on December 29th, 30th, all in December, we used to call it the taxi shuffle or the Medicaid shuffle or the it was like people wanted to get downtown for free without calling a taxi. And no joke, they would call the ambulance, right? We would take them to the hospital and
Yep.
they'd walk in and
And
they'd
they
walk right out.
we've had some jump out at the hospital. Once they get they jump out, say thanks, and they walk away. They're
Yeah.
not even intending to go in the hospital. They just walk out. Yeah,
Even more
I
brutal.
know.
So I get it. I wish there was a better way. And yet, again, how is an EMT supposed to, and you're not supposed to, right? One way or the other, you're not supposed to make it look worse or better, just report it as you see it. But how are we supposed to be the intervention of, inappropriate billing?
And I think the folks, and I hope I don't insult them. I probably have already insulted ER docs, but the folks who have not been on the line in a while, they have not been on runs, firsthand, they're first in, tend to forget, and they don't realize the trauma, the psychological trauma that is impacting medics day in and day out with this crap.
Yeah.
And I think that's really unfortunate.
Agreed. All right, let's go to Kentucky. Um, this is one of those where we say it's going to be interesting to see how the lawsuit turns out. And I'm guessing there's going to be a lawsuit.
I'm guessing too. And I did get some feedback that said the IAFF on the national level had intervened, but I haven't seen anything on that yet. So certainly, if anybody out there is privy to what's happened there, that the IAF has intervened and they backed down on this, but I have not seen it. So we're assuming that union president is still terminated.
So yeah, so let's go through it. So I don't know if it's Paducah or how you pronounce it.
Paducah, I guess.
Paducah, yeah, city commission. So they voted unanimously to terminate a captain from the fire department. They had a 9-hour disciplinary hearing. This guy's a 22-year veteran, right? He's also, interestingly, the president of the IAFF local. So, and he's held that position for like 5 years, probably 7 years, 8 years. So here's what happened. And I want to go through some of the charges because you start to get you'll get your own flavor, I think, for the viewers. So they have a number of charges, 9 different ones. They found him guilty on 6. I always tell my clients to do that too. Well, don't find him guilty on everything. You look more credible if you dismiss some. You look more like you're
There you
being
go.
more
They were
neutral.
listening to you, Brad.
Yeah, probably. So, but here the charges are interesting. So he claims that this is all retaliation for union leadership. And so, but the lawsuit, if and when there's going to be a lawsuit, is going to be based on the validity of the charges, right? So here's the thing. So again, they're claiming this is retaliation for protected union activity. And the charges appear to stem from 4 different incidents. So remember, 9 charges, 6 he's guilty. So one is, and on the scale of, oh, come on, please, sure, I can see that, right? The first is the captain on a call, right? Which again is not calm and orderly with thought for reflection, right? A captain on a call referred to a newly promoted officer by her previous title, right? So she became a battalion chief. She was promoted to deputy. She became the battalion chief. She was promoted from deputy fire marshal months earlier, and he got on using the term marshal, fire marshal, something like it was derogatory, right? And so the city says, well, that wasn't a mistake. It was intentional and it was disrespectful. And the captain's saying he would never blatantly disrespect a chief officer. But they, found him guilty on being rude and impolite. On that one, my own personal feeling, I'm calling BS on. But again, I don't know. Another charge, the captain, This is again on this you got to be kidding me scale. So there's a lawsuit, a motion. It was a lawsuit by the local against the city over a residency requirement, which mandated firefighters live within 45 minutes of the station or of a station. And he called, the captain calls the court, just asked, and that doesn't talk to a judge, I presume, probably talked to the clerk.
Left a voicemail. Yeah.
Yeah, left a voicemail, even worse, and says, when would the decision be out? Right? Well, people don't know. That's a fair question. I've even done it after a while.
I can tell you, I have watched these types of lawsuits take place, or especially over a real polarizing topic like residency. And as the union president, he's probably getting 10 calls a day from his members. Hey, what's going on? What's going on? And he finally is like, all right, let me see what I can find out.
Yep. And he makes a phone call, and the city says that, you're trying to interfere. It's conduct unbecoming. And his attorney's like, come on, this is ethically permissible. And by the way, it is. There's nothing wrong with calling a court clerk. You're not having ex parte communications with anybody. I always call the court clerk. Everybody calls a court clerk. I was a court clerk for the judge, and you're kind of the intervening ex parte. So the rule to everybody is you can't have a one-on-one conversation with a judge unless the other party's right there. That's called ex parte. But you certainly can call the clerk, and that's the role of the clerk, to intervene and give some, thoughts and whatever. Anyway, that I go on the kind of the, you got to be kidding me scale. The third incident, okay, maybe a little more legit. It was the captain, the plaintiff, or the person terminated, and two other union officials wanted to accompany a firefighter to a meeting, and the city attorney and HR director, this is a Weingarten thing. So kind of, they wanted to accompany a firefighter who was a witness, right? Allegedly a witness, not under investigation. And they tried to accompany him, and I guess he was told, listen, he's not the subject of investigation, so he has no right to representation. There was some back and forth, and they left and filed a grievance, right? And they said filing of it was impolite and rude, and they were impolite and rude to the HR director. Who knows, right? I don't know whether they're rude or not, but the general Weingarten rule that says if you could possibly be the subject of an investigatory interview for discipline, right? And unless you're warned otherwise, you have the right to representation.
You have a right to representation. Here's the other thing. It's not what the investigators think. The investigators can think he's a witness. If he, in his mind, thinks that he is possibly going to say something that could get him in trouble, he has a right to a union rep.
Yeah, so they were right.
So I don't know.
Right. And so, but I don't know.
To me,
it's the very thin, right? And then the fourth set, I don't even understand this, honestly. The captain wanted to attend an area maritime security committee meeting. It was in August last year.
It was a public meeting.
Yeah, and he didn't have approval for it. He allegedly, the deputy chief who had testified at the hearing, said that the captain had been instructed not to attend. And so he said, but I was also encouraged to attend. So which is it? Now, this one may be more on the legitimate scale. So he was found guilty of insubordination, engaging in a dispute with the chief over the matter. But he was cleared of acting rudely because, I don't know, the meeting hadn't occurred or started yet when this call of don't attend, occurred. But so I don't know. I mean, if he was insubordinate, maybe, right? That's maybe if you were told not to attend, and if you were attending, that's my other question. Who is he attending as? They can't tell him not to attend as the union.
That's
the chief can't tell him not to go to a public meeting as a union, but if they were paying him and he put in for time, that would be different. But to me, this is the big one, because if they go after him for union protected activities, attending a public meeting as a union official, that would be, that's different. You can't tell someone not to attend a union meeting, right? You could talk about time off or whatever. In any event, that's it. This is going to turn into a lawsuit. I don't see how you're going to avoid that. And
sometimes, folks that come into government as elected officials don't understand labor law. They don't understand a lot of things about how government works. They get elected, and then and this goes also for like city managers, town managers, HR directors who spent most of their career in private sector, and they come in and they find themselves in this, and they think they're going to handle things the way they would do it in private sector. No,
Right.
no, this is different.
Right.
So
Yeah, I don't know. When I see, that there's an HR entity to, these bigger the departments, you think they're going to get better advice, but you always talk about the disconnect between HR,
mhm.
right, and the rest of, the department.
Well, yeah, and I've seen it. I've seen like highly credentialed HR people, like Fortune 500 level HR people, and they're friendly with maybe somebody who becomes the mayor of a city or mayor of a community, and the mayor says, "Oh, you're great. You've been working in a Fortune 500 company." They've got absolutely no conception about public sector responsibilities, and all of a sudden they're back on their heels a little bit. And of course, they've got a wonderful pedigree of working in the private sector. They're at the top of their game there, but this is different. It truly is different. Yeah, I can see First Amendment claims. There's certainly wrongful termination, unfair labor practices, and possibly First Amendment issues coming out of this. This is,
Oh, absolutely.
yeah.
Absolutely. I maybe you want to handle the next one, the settlement between the IAFF and the NFPA.
Yeah,
Um,
this is really, it's unfortunate. I mean, two organizations that I care deeply about and I have utmost respect for. Certainly my former employer, the NFPA, I worked for them. I've been a member for, almost half a century. And, but, the IAFF, I was a member of the IAFF. I do a lot of work for them. And I have the utmost respect for what they mean, not just for career firefighters, but for the fire service in general. But 2 years ago, they filed suit over the fact that despite what the IAFF was trying to caution the NFPA standards process about, there was some problems with PFAS in turnout gear, and there was some things that needed to change in the language of the standards that would allow for some alternatives. And it wasn't so much an alternative in terms of products, but it was more about the testing process, and in particular, the 40-hour ultraviolet light degradation test. And apparently, at the time, the only product that would pass that test was going to be something that had PFAS in it. So, looks like whether technology has proceeded or whatever, but it looks like they've been able to overcome the challenges that they were battling out in court, and they agreed to dismiss the suit with no consequences to either side. Each side, I guess, is going to be responsible for their own legal fees. So,
yeah. Okay, so we'll see. And that kind of relates. I maybe just to jump for a second to the last case in Virginia. Why don't we,
yeah,
just jump to that?
sure.
Because we have a Virginia firefighter who's now suing the PPE manufacturers, claiming he got leukemia from the PFAS in the turnout gear. So related, the 3M is going back and saying, listen, we complied with everything. We're up front. I look at it as a proximate cause issue, and they do too, saying maybe you got it from foam, not from the turnout gear and such. But I don't know. It's going to be very tough. But I don't know. Is there a science yet that conclusively establishes that the PFAS in the turnout gear? It's one thing that's in there. It's like having asbestos to me, right? You can have asbestos wrapped insulation pipes. Don't disturb them,
Yeah.
and asbestos is safe. So here, and I think I remember you making a comment a year and a half ago when this whole thing started, that the PFAS where it is in the turnout gear in the line or something may not necessarily be harmful. I forget if that's what he said, but do we have a proximate cause? Do we know that PFAS in turnout gear actually causes these issues? And the reason I'm skeptical of it, I'm not saying that it's not there, but that it actually causes harm, is the number of people who wear turnout gear, volunteer and career, us for decades, right? All these people who've, knocked on wood, who then have some condition that we can trace to the turnout gear, not to something else, foam, or not wearing our mask during overhaul, or the hydrogen cyanide or sulfites and all that. Do we actually know that the turnout gear, is there science that's concluded turnout gear itself? Because the numbers are so low of cancer from this.
Well, I don't think there's any question that there's PFAS in the turnout gear. Okay,
Right.
whether the PFAS can get from getting on your skin can enter your skin in sufficient amounts to create a problem, I think is open. And I've seen, like, I get it. Folks that have cancer, they want to eliminate all possible risks to anyone about being exposed to chemicals that can cause it. And I totally get that. I don't mean to trivialize that part of it. Okay, but our skin serves as a pretty strong barrier to most types of products. There's certain exceptions, benzene being one of them. There's certain products that can go through the skin, pass through, and can cause problems if you get it on your skin. But most products are not. And so that's sort of one issue there is there science that it can go from the product onto your skin, through your skin, inside? We know that if it gets in groundwater and you're drinking it, that is a super likely way that people can get something like leukemia or other forms of cancer. So PFAS in groundwater is highly is to me is a much bigger concern. Breathing in whatever it may be is another big way. But having skin contact with it, I'm not I'm not sure. I haven't seen any documentation that somebody wearing it uh, minutes later, hours later, then has it in their bloodstream just strictly from wearing it. Now, the other problem is the PFAS is ubiquitous out there. And
Right.
literally, if you have Gore-Tex, if you have a Gore-Tex parka, ski parka, or gear, it's got PFAS in it. You know, Teflon pans where, we used to cook eggs and pancakes. Teflon has PFAS in it.
Right.
And that's going in your mouth, in your body. And there's plenty of documentation that when things are ingested or inhaled, they're going to get in your body and they're going to cause problems. So again, are folks looking at the exception to the rule here in terms of the turnout gear and ignoring the bigger problem? I'll give you another one. I use what do you call it? A product for for what do you call it? Cleaning your teeth called Glide.
Okay.
And just to what do you call it? Clean your teeth, and that's got PFAS in it. You know,
Right.
it's like
Right.
what? So,
So how do we prove proximate cause?
well, that's what I'm saying.
Right.
And I can see and this unfortunate firefighter. I'm not trivializing,
Of
his
course not. God
condition.
no.
But
God no.
have you ever worn a Gore-Tex jacket? Have you ever used Glide, as a tooth care product? Where are we going with this?
Right.
Did you ever have an omelet that was made on a Teflon
All right.
pan?
There's so many ways. So
Right.
many.
So, but I think the AFFF is another one that's a bit, I mean, that's obviously a concern. And I think there's a difference when you put your hand or you're standing in um, AFFF or
Yep.
you got it on your skin versus you have a jacket on.
I think I have pictures of me. This is what scares the hell out of me, but I think I have pictures of me because we look like the Stay Puft Marshmallow Man. I was in so
Oh,
much foam and people
yeah.
are taking pictures. I'm standing there, with all the foam all over. It was funny at the time. And now I'm looking like, oh my God. Um,
I'll tell you, when we first got AFFF in Providence, we were told that it was basically expensive soap,
right.
and that once it reached its 10-year life, you could use it as soap, and we would use it to scrub down the apparatus floors. Every Saturday was a scrub out day. You scrub the apparatus floor, and we would use that. I remember as a pump operator, as a drive chauffeur, we called it. One of your responsibilities every day was to check the foam tank. The foam tank was on the driver's side rear tank, and you'd open the cover and you'd put your fingers in it and make sure that it was up to the top. If not, we'd add more.
Yep.
But again, we were told it was nothing more than soap by
Well,
the
we
by
used
the
to have foam
salespeople.
wars. We used to have foam wars. I mean, and we had containers of the stuff, and there was the bad smelling stuff, right? Which is
Yeah,
the
right. It was the fish
AFFF.
guts, right?
Right. And then there was the better smelling stuff, which right, smelled better.
And
So
work better, by the way. That
yeah,
AFFF, yeah, you've seen it work at fires. I mean, it's unbelievable. I
yeah.
mean,
Well, so
the
was
kid,
asbestos, the fire blankets.
well,
They
there
were
you go.
also unbelievable.
There you go.
Anyway, but we're not discrediting the firefighter.
No.
It is just very tough to prove, right? Very tough to prove this.
Mm.
So that's ultimately going to be the issue.
Yeah.
So, okay. So next and last, let's go to San Jose. This is a big ouch. This is going to be if everything that's said or most of what's said is true, somebody's going to write a check. The big if. We don't know. This is just a lawsuit. So we're in San Jose. We have a fire department engineer, a female who's an Asian American engineer. She's filed suit alleging what you think discrimination, harassment, and what goes with the two of them every single time
Mhm.
retaliation. And it's always the same facts. We'll get to that. So she has filed saying that, and she's an Asian female of Taiwanese descent. She's filed saying that I think it was the chief, has been making consistent comments. Let me explain some of them about her. So, allegedly, we don't know the truth. This is what's alleged, that the chief said that she was MIT, made in Taiwan. The chief allegedly learned that she had children, and he allegedly referred to plaintiff's children as ABCs, American-born Chinese. This one is out of Crazy Rich Asians. I was laughing when I saw this, not because it's funny, but it came from the movie.
Oh, I
At
was
least,
wondering where it came from. I didn't realize that it came from a
well, I
movie.
don't know if it came from them, but the two women in Crazy Rich Asians say, "Yeah, you're like a banana, white on the inside, yellow on the outside."
I didn't realize
Which
that.
yeah, but what's interesting about that in the movie, when they use that phrase, she was saying people think I'm Asian, right? But really, I'm not considered by my own people as Asian because I am, I look it, but I'm really white on the inside. So it was kind of the reverse, honestly. But okay, but that was just one. Allegedly, that plaintiff's daughter, who was, they made a comment. It had nothing to do with work, but it was derogatory about the daughter. Then there were meetings, and she was present. And the defendant, the chief, allegedly told her to enunciate. I don't know if she has an accent or something. And that these comments were made in front of other coworkers. So she said she was humiliated. And then the retaliation facts are always the same. Take this paragraph and plug it into any case we've ever covered. She allegedly reports it and then suffers more retaliation as against it. She's passed over for promotions, allegedly in favor of a less qualified male. So she's ticked every box that she needs to check to get to a jury. This is not getting dismissed under the McDonnell Douglas test, saying they can show another reason. There's too much else. This is going forward. So as far as I'm, concerned, keep watching. All right, there's going to be more.
As I read it, all I can think of, I mean, I've spent my entire adult life with firefighters, and I think of what happens when we have people who've been socialized in the fire service and they come in contact with non-firefighters, and they're acting like they're making the same kind of comments that they would make in the firehouse that would just be laughed off by some people. And when you're dealing with a civilian, particularly an engineer, who isn't aligned with our culture and our sense of humor, and certainly these things, we've got to realize there's jokes, there's things that are said in the firehouse that if quote unquote normal people heard them, they
Yeah.
would be deeply offended, and that's going to include juries, I think, in this case.
Oh yeah. Oh
So,
yeah.
yeah,
So you don't want to be here, right? You don't even want to be close to these types of allegations.
right.
So that is it for the week.
Yeah, yeah. So, and we got a holiday week this week. I guess tomorrow will be the first real work day, but I guess that's going to wrap it up for another edition of Fire Law Roundup. First of all, if you're still listening, thank you for hanging with us for this whole, we're up to about 35 minutes here, so we appreciate it. Please click like, please click share,
follow Curt's website because tomorrow we should learn, right? One last topic.
Yeah.
We should learn that, and we talked about this last week, that the United States Supreme Court has been reviewing an application where they're being asked to consider whether the Seventh Amendment, the right to a jury trial in a civil matter, including administrative matters, is a right that's guaranteed to the states, meaning that the state has to give you a jury trial in a civil matter and an administrative matter in certain matters, like well, like a lot of things, but certainly before they take your EMT or paramedic away, or doctors and nurses, same thing. In any event, tomorrow we should hear one of three things. One, that they're going to agree to hear the case and they grant certiorari. I give that 50-50 odds at the moment, because they were supposed to decide last Monday. They kicked it to Friday under a judge's conference, and they kicked it now to tomorrow. So either they're going to hear it or they're not going to hear it. Or, frankly, what I'm kind of rooting for, they're not going to hear it, but hopefully they write an opinion that the judges who wanted it to be heard but couldn't get it heard either write an opinion which said this wasn't the proper case for this question, but it's still an important question and we'll wait for the next case. That is a possibility that could come out. They call it a vehicle. If the case is not the right vehicle that they're reviewing to get that question, there would be another case coming at a later date. That would be our case coming from New York State. But, look, for the benefit of everyone, hopefully it's just granted they agree to hear it. But this is going, and you and I will cover it a lot more as it goes on, whoever case it is. But this is going to affect firefighters, EMTs, paramedics, doctors, and nurses heavily. Yeah. So we'll see you tomorrow.
All right. Well, that's great. All right. And that's going to do it for another edition of Fire Law Roundup. Brad, thank you. We'll see you next week.